time, bro.
Hello. Hey. Awesome. Thanks so much, everyone, for coming. I know business stuff isn't always the, sexiest topic, but I think it's so important, and this is an amazing group of people that we have up here. So big thanks to Audiokinetic and Simon. And yeah, so just to see who's here, how many people are more on the non-game side and kind of interested in getting into games, more film, TV, composers, show of hands? Okay, and then game-focused people. Okay, pretty good smattering of both. Awesome, and yeah, anyway, well, I will introduce the awesome round of panelists here, and then we're going to dive into a bunch of different topics. But yeah, so kind of going down the line, we've got Jeff Rose at the end, an amazing attorney. He's been working in music and games and games and games and games and game music for many years. Works with my own company, Hexany Audio, Tommy Tallarico Studios, Penka, I can never say Penka's last name, Kuneva? We'll go with Penka. And she's just like, Cher. Anyway, you don't need the last name. Cliff Eidelman, Quiet Riot, many, many people. Sebastian WOLFF co-founded Louder, which just got bought by Spotify and is now doing Materia collective stuff. He's our guru of music rights and money and how to suck money out of game music, squeezing the little drops that are there. Brian Schmidt from everything in game audio. He's been doing this for a very long time, was at Microsoft, founded GameSoundCon. Basically, if he wasn't here, our community would implode upon itself. And then Sarah KOVACS from Kraft-Engel here in LA, agency representing all the biggest composers that you can think of, and quite a few on the game side, Austin Wintory, Bear McCreary, Gary Scheinman, bunch of different people. So really great brain trust. And I have a company here, Richard, by the way, I'm super ill, came right out of bed and just downed a bunch of cold stuff. So it's gonna be great. But anyway, so yeah, we have a number of composers and have worked with Jeff and working with Sebastian now, so great people. Anyway, let's dive right in. Jeff, an attorney, what can I expect an attorney to do for me as a composer? I come to you, and also, when should I come to you? When do I know that I need one?
You should always come to an... Am I on?
You are on.
Okay, so if I would come to an attorney as early as you start doing business, as soon as you start doing contracts.
Can you guys hear Jeff okay? No.
How about this? Okay, there we go. Perfect. So you should go to an attorney as soon as you start seeing contracts, as soon as you start doing business. Attorneys, we are known as counselors, we're lawyers, we do all kinds of roles, but we can help you set up your business, understand what your goals are going to be, and understand what you're doing. I always tell clients that what you're going to do is you're going to need a team of advisors. A lawyer is a member of the team of advisors you're going to need. You're going to need someone to help you with accounting. And when you get big enough and you have employees, you're going to need someone to help you with doing stuff with employees. You're going to need somebody to help you with insurance. Lawyers can serve several different roles for you. We can help set you up with a corporation to understand the risks that you would face. We can help you with contracts, both in terms of hiring employees, acquiring content, and then licensing that content out to customers, or doing work for hire agreements, doing licensing agreements. Just to help you understand what type of work you want to do, how you're going to make money, and protect yourself. But really what you should do is think about it as you need a team of advisors that can help counsel you and advise you as to what types of strategic issues you're going to have to consider to allow yourself the freedom to go out there and be creative, make great music, and be a successful business. When should you hire a lawyer? Straight away. I represent primarily startup companies. I'm usually the first lawyer most of my clients have ever hired. So I understand it's scary to hire a lawyer. It sounds really expensive to hire a lawyer. But I'm interested in building long-term relationships. I've had clients for 25 years. When they first came to me, they didn't have the money to pay me straight away. So I will invest in you if you'll invest in me. I like to answer questions. I'd rather you ask me a question up front rather than coming to me with a mistake a year down the road. But start talking to lawyers straight away. Most of the people in the game industry are very open about talking with young people and making sure you don't make mistakes out of the gate. And we will take you kind of on the promise that you're going to develop into a long-term client. So don't be afraid. But when you first contact a lawyer, be very clear about it. It is a business relationship. As with anything, as part of a business, you want to be clear what the understanding is, what you're going to be charged for, what you're not going to be charged for. You know, like I said, I'm a professional. I am running a business. I will be very clear with you as to what I expect to get paid for, but I'm also very open about, I understand if you can't afford to pay me straight away, I will help get you to the point where you can pay me.
Awesome. And I think, at least when we work with you, it's as an hourly rate. We're not really asking you to negotiate contracts. The terms in them, I think that generally falls more to an agent and that type of role. Sarah, can you tell us just briefly, what does an agent do for a composer?
So an agent...
You bring us work, right? Right?
Yes-ish, asterisk. So a big part of what we do is broker the deals. We are licensed as an agency in the state of California, where we are legally allowed to do that. But honestly, making the deals, discussing numbers, negotiating the rights, the percentages of this or that, is kind of a small sliver. It's a big part, and it's an important part, and we try to be known for the agency that will get you the best deal. The company I work for has been doing this a really long time, 30-plus years, and so the roots of experience are really deep, and the relationships are really deep. So that is really useful in the deal making, but a lot of what I spend my time on is the guiding, it's the counseling. Trying to decide when you have 4 or 5 offers on the table, well, what would make the most sense? A lot of times we'll talk to our clients about the 3 buckets. If you've heard me talk on a panel or anybody I work with, we talk about this a lot. The 3 buckets are, is this good for my career? Is this good for my bank account? Is this good for my soul? And depending on where you're at in your career, you don't need to have all 3. You might not even need to hit 2, but if it's appropriate, depending on the situation and the project and the people involved, maybe you need to hit 1. So, and we have composers at different levels. We represent Danny Elfman, Alexander Desplat, John Powell, Alan Menken, and people of that stature. And we have a few up-and-coming growing composers as well that we are investing in. So there's a lot of guidance, trying to figure out what to say yes to. Composers starting their careers are investing in their own career, and so trying to guide them on how best to do that and sort of strategically planning where to put their limited resources is a part of it. So with that, and that, I guess, is the management side of what we do as a company.
Great. And as far as contracts that you are negotiating, are most of these work for hire nowadays in the game industry? Are some of them licensed deals? What's the percentage that's work for hire?
I would say I have not yet done a deal with a AAA that's not a work for hire.
And along those lines, do your composers usually get to retain the PRO rights for their writer's share?
Always.
Always,
Yeah.
okay.
I won't
awesome.
do a deal. We just won't have that conversation.
For sure.
It doesn't cost a company anything to allow the composer to receive public performance income that they're not paying. The game company does not pay public performance money. They are a recipient of the publisher's share of that income, and I have a lot of those educational conversations. I have the same email that I created a couple years ago. The first time I had to have that conversation with the company, just drafted it, and I ran it by a lawyer friend to make sure I sort of made sense and what I was saying was all true, and he blessed it, and I sent it off, and I've used it a few times because sometimes people need a little bit of gentle education, so we do that.
Sure.
But yes, usually it's a work for hire if it's a Sony or a Microsoft or an Activision or an Ubisoft or what have you. But there are a lot of indie developers, and those are definitely license deals. Or we do a co-pub, we do a 50-50. There's different arrangements that can be made depending on the circumstances, depending on who the company is. Sometimes it's just a few people creating something really special, or sometimes it's a bigger mid-level company that believes in the artist and wants to share in that with them.
For
and
sure.
it always depends on the money. You know, if they don't have a lot of money, then they can offset that by offering some rights or some bonus points or what have you.
For sure. Yeah, and I want to dive into the PRO stuff more, but really quickly, Jeff, can you give us what is a work-for-hire agreement, and what are the rights that are, basically surrendered in doing one?
Well, it all has to do with copyright law and who owns the work when you create it. And the way the copyright law is written is that when you create anything, writing notes, drawing a picture, creating music, when you create it, the author owns the creation. A work for hire is basically where you are saying that I am doing this on behalf of someone else, and you are giving up your rights as the author, and they will, the person who you're creating it for will own the rights upon creation. So it's a very technical thing in the world of copyright, where it's a magic word situation, and there are very few magic words in the legal world. But in order for something to be a work for hire, you have to have a written contract that says you are agreeing to create it as a work for hire, and you have to have that in writing before you start creating the work. So when you see an agreement, it's going to have these tiers where, I agree that I am doing this as a work for hire. If for whatever reason, 10 years from now, someone decides this is not a work for hire, for instance, you started working on it the day before you signed the contract. So any work that you worked on the day before can't be a work for hire, so you assign those rights to the publisher. And then the third tier is going to be, okay, if some obscure law in France or Spain or somewhere says that you can't assign those rights, then you give them a royalty-free license to use those, whatever you created, in perpetuity without any royalties. So it's really it's a very technical way of defining who owns a work. And it's important for publishers, because if they're going to go out and exploit the work, they have to have a definitive answer as to who owns it. So if you have a contract that says you're doing it as a work for hire, and if there's 150 people working on the project, and they have all agreed it will be a work for hire, then it's very clear that the publisher owns those rights. So, and it can get more technical. If you are an employee of a company, automatically everything you do is work for hire. But there's only like 3 ways to get ownership of a product. Either you create it as either the creator or an employee of the creator, you have signed a work for hire agreement, or you assign it to them.
And inherently, with a work for hire, you do give up your PRO rights, correct? I mean, even if ASCAP and BMI have a policy of not paying them out to people other than the author.
Technically speaking, you have given up all ownership of all rights of anything. And we can talk about why they don't, sure. How PRO rights came about in copyright law and music law is this weird tangle of laws. But sure. Technically speaking, as a lawyer, yes, I would say when you sign a work for hire, you have given up everything.
Great. Well, awesome. So, Sebastian, you run Materia Collective. It's a music publishing company, a record label. Record labels are evil, right? I mean, like, that's a thing. So, what do you do for a composer that they can't do themselves? Or what do you take care of on that side? And, what does your work encompass?
Sure. I mean, within the music space, you will absolutely run across a lot of companies who might be defined as evil. There definitely are labels who, have four-letter words associated with it. But I'm a firm believer in DIY, and it's almost 2019, and it's easier than ever to, be your own creator, be your own publisher, rights administrator. It's easy to publish, to distribute, to manage all of your rights yourself. But at a certain point, you run into there are only so many hours in a day, and like Sarah and Jeff have already expressed, it's nice to work with experts who care about a very tiny sliver of your career that then becomes very important. So with Materia Collective, we do music rights administration, we do music distribution, we print CDs and vinyl and sheet music, physical media, floppies. And the way I like to approach it is very much from I'm part of your team, I help you pursue opportunities that otherwise, many composers and creators might not actually think of. Mm-hmm. I'm very good with technology.
Yeah, so I mean, my company's, makes like 99% of its money from, hey, we would like music, give us music, we will give you money. But this back end, be it soundtracks or, performance royalties, is there money to be made there for video game composers?
Absolutely.
And what are the avenues there?
There are hundreds of avenues. The way I like to approach royalties and residuals is sort of, this is your legacy. From a copyright perspective, depending on who exactly the rights owner is and who the payee is, you might be looking at royalties for your creation until the end of your life, and then for your estate for an additional 75, 80, 85 years, something in that realm. We'll see how copyright law changes, but instead of just having a single payout for a creation that you might receive, you have an entire lifetime of royalties that you might receive. So it's interesting for me to look at it like, oh yes, 100 years in the future, we will still be potentially helping composers get paid for something that they have created, or their heirs and assigns. So in terms of royalties and residuals that can fall off, we have digital distribution. There are CDs and vinyl. I know we have sheet music is making sort of a comeback. It's very new to video games. And then on the back end, of course, PROs, ASCAP and BMI, they collect for performance royalties in certain territories in Europe. They also collect for games. So, for example, if a game sells on the PlayStation Store, there is a certain royalty that falls off that a specific country's PRO might collect and hold that would have to be proactively collected.
For sure.
And copyright law, generally speaking, is slow to evolve. I think is a good way of putting it. But that said, there are very many different avenues that the last 100 years of music copyright have shaped consumer models and different types of residuals that might fall off. Not in all cases is it where you purchase a piece of music or you purchase a CD and that is the price that someone receives. It is, well, a stream on Spotify is a master use where a distributor gets paid.
Yeah.
You have a performance license that gets paid to ASCAP. You have a mechanical royalty that falls off to the Harry Fox Agency or Music Reports or someone else. And it requires a whole bunch of due diligence as a composer and a rights holder to sort of chase those down.
How about spreadsheets?
I love spreadsheets.
I love spreadsheets too.
Can we be best friends?
Anyway. Well,
so
yeah.
it's a lot of diligence. No, absolutely. So
Great.
It's fun.
So speaking of the last 100 years of copyright, you've basically been there the whole time, Brian. How have just kidding. How have avenues of revenue changed from back in the 1800s from today for game composers? Not really, but really, how have they changed over the course of this industry's evolution? Where were you making money primarily 20 years ago, and what about now?
It's actually surprisingly unchanged. Actually, I started, I think it was 31 years ago, not 118 years ago. Thank you very much. Mr. Forbes magazine, most important 30 under 30. Congratulations.
Sure. Unexpected.
Where were we? When I started in the industry, actually everything was work for hire because virtually every piece of game music was created by an employee, a full-time employee of a game company. The whole notion of freelance composers for video games almost didn't exist in the 80s. That wasn't until the 90s and certainly the late 90s where it really kind of took off. So I think that's where the notion of the game company will own lock, stock, and barrel absolutely everything, kind of where that mentality
For sure.
Certainly for games came from. And the majority of payment of music for games is kind of like what you said. It's like, I give you money, you give me cash, we're both happy.
I give you money, you give me cash. Probably I give you music, you give me cash.
Sorry, I give you music, you give me cash, and we're square.
Yes.
And one of the things I think that surprises a lot of, especially film and TV composers who come into games, who are used to getting the majority of their income through PRO payments, is that with a couple of exceptions, one of which Sebastian mentioned, in the normal course of playing a video game, there is no performance going on from a legal perspective. So there actually aren't any PRO payments. And most game composers actually, ASCAP is, up until relatively recently, PROs have been relatively insignificant
in the game
for game composers. You do a game and it sells 10 million units, there's no performance on that. Now there is something where if you were on the PlayStation Network purchasing a game in certain EU countries, part of that is considered a performance, part of it is considered mechanical. It's still kind of the exception rather than the rule.
For sure.
Now there are some weird things starting to happen with Twitch TV streaming and esports and things like that, where you're starting to see game music broadcast in the more traditional sense. And in that sense, PROs do get involved, although there's some sort of scary stories about game composing and PROs as well. So.
Yeah. And as far as PROs, Sarah was saying that like 100% of their deals, composers keep the PRO rights, even if there might not be a lot of money in them for games. In your experience, have you had to give away those? I mean, often in our work, especially with overseas clients, we've just basically given them away because, people haven't wanted to become educated about it, and they'll just kind of move on to someone else who would give them away. What's been your experience there?
Yeah, for the most part, the game lawyers have no idea what the heck a PRO is. And when you try and stick in a clause that lets that in a work-for-hire agreement, because everything is work-for-hire, virtually everything is work-for-hire, if you try and stick in a PRO clause that lets you collect your ASCAP royalties, that's a big red flag from the lawyer. And almost every time I've had to give up on that clause. And again, I personally haven't minded because I don't see lots of potential lots of revenue, but it's been I've been told flat out that is a deal breaker. And part of it is some of these games aren't, if you're not doing an Activision or a Blizzard game and it's only a $50,000 music package, then they don't want to have to spend their time educating their lawyer on all of this stuff.
For sure.
And so
it is great to see though that agencies like Kraft-Engel have that, here's the deals we've been doing, these are the deals, and you are able to get those. I think that's maybe a little bit different outside of the AAA kind of US Western world where other people are not as, you guys have educated the US AAA market, I think, a lot more perhaps than for other smaller developers and whatnot. But
yeah, and some of the game companies are very, very savvy. EA is super savvy, Microsoft, Activision, some of them are very, very savvy when it comes to PROs and composers, and they realize that when the music from World of Warcraft gets used in the South Park episode, that everybody makes money.
Sure.
But unfortunately, that's not the case. And in fact, in one case, the opposite happened. Simplifying the story a little bit, I was commissioned to do 3 minutes of music for a friend of mine doing with a game company in Chicago who was doing it on contract for another company. Did it, gave them the music, got paid. The company wouldn't use it because I belonged to a PRO.
Good times.
So there are some game companies that are starting to get scared of PROs because of stuff they've heard or things like that.
Sure, yeah.
But that was a big eye-opener, and that was within the last 18 months.
Yeah.
So that was kind of a big eye-opener, that this one particular company is no longer using composers who are in PROs except as actual employees.
Wow.
So they are now hiring in-house composers as full-time salaried employees.
Sure, yeah.
And that's the people who are writing all their music now, which is good for them.
Yeah.
It's a little scary.
I was just going to add, in my experience, the tide is turning. And it's turning very slowly, but the tide is turning where 2 years ago people would just look at you sideways and say no. Now there are companies out there that understand it and say, yeah, no problem. literally have no problem with it at all. And there are others that if you talk to them and push a little bit, they will accept it. And still others you kind of have to push a little bit more, and they're uncomfortable. But again, there are companies out there that go PRO, no, deal killer. And so.
Yeah. So what about soundtrack sales? Are composers usually able to retain a percentage of that, Sebastian? What percentage are you seeing people able to retain? And then next, I'm curious what you would say, Sarah, here. But yeah.
I've seen everything all across the board. I think with indies especially, it's pretty common for, for smaller projects, smaller budgets, for composers simply to do license deals
For sure.
and retain ownership, all of the collection rights, soundtrack rights. In some cases, a label or a publisher might separately go to the game company and ask for, different rights, trademarks, character usage rights and stuff. But I think on the larger end, AAA pretty much all buy out with the PRO carve out in some cases. For soundtracks, we've definitely done a couple of different deals where, part of the revenue goes to the company or part of the revenue goes to co-composers or, even some cases of co-publishing deals where revenue is split up on the mechanical right. It gets really fun with accounting.
Spreadsheets.
I love spreadsheets. But everything, it all depends on the deal. And it's nice to work with, music platforms that sort of understand that, with music rights, there isn't really a standard. Every deal is different, and the music world is just filled with edge cases and exceptions. So it makes it really interesting to kind of carve around that from a soundtrack perspective.
Yeah.
Speaking of soundtracks, I think there's a lot of really cool things that are happening, especially in the last 3 to 5 years. More labels are popping up, lots of vinyl is being produced, CDs.
Because it sounds awesome.
It's amazing. I love
Well, hey,
I love vinyl.
Yeah, there you go.
Can we do a vinyl?
Anyway, okay, great. And Sarah, at the AAA level, soundtrack sales, are composers able to get a percentage of that? What does that look like? What's a reasonable ask?
Usually, so a composer typically, and not just in games, but in film and television, it's usually the same. It's anywhere between 11, 12, if you're a Danny Elfman, 13%. And that's broken into 2 numbers. There's an artist royalty and a producer royalty, the artist being the composer who is performing the work. Even if you have an orchestra actually performing it, the way it usually goes is the composer stands in as the artist. And that's like 7's sort of low, but 8, 9%, and then the producer royalty is the other part of that, the 3, 4%.
And who's usually getting the producer royalty?
The composer, because they are creatively producing.
Sure.
They are, when you get hired, they give you money and you hand them a finished product. I've never had a composer write on a piece of paper, here's my composition, and then they go, the company goes and creates it. Now, there are music and audio departments at big publishers who have incredible audio departments, who have their own orchestrators and their own mixers, and usually their team and the composer's team will work together. And the audio department will be pretty hands-on in also helping produce it, and sometimes you'll see, Sony, for example, they're very hands-on producing scores, and they're great. But the producer royalty for the composer, that goes to them. I've never, with a work for hire, there are, for me, a certain set of standard royalties that our composers get. That's definitely writer's share of public performance. It's the soundtrack royalties, it's mechanical royalties. And the one I find that I have to fight for a lot, I don't really get people pushing back on the writer's share of public performance. It's sort of a no-brainer, but the thing that people are like, wait, what? Is the 50%, what I call the writer's share portion of all publishing streams, not just the public performance, because public performance is just one way you can make money under the umbrella of publishing. Sheet music is one of them, but really the big one is the sync licenses, and third-party master use license as well. So if the music gets licensed in an Audi commercial, for example, the composer should get 50% of that fee, and so there's a lot of conversations around that. I get pushback more on that than anything else. But for the work for hire, all of those things are standard. And I've not really had the experience of dealing with a big game company that has said, no, we're not giving you that.
Sure.
Some don't like to give the master license use. And then with the smaller companies, I find that you can get very creative in the deal making. You know, they sort of don't really know what they're doing, and so they kind of look to us to guide them. We often recommend they hire a music entertainment lawyer to help them. They deserve to, you know what they're signing and getting into. There is this everything's a work for hire for the most part, but a lot of the deals we do aren't that. Maybe some of it is, maybe it's a work for hire, but they let the composer put the soundtrack out completely and collect 100% of that income. There's so many different variables, and you can use these as tools. Like, I'll give you this if I can keep that, and that's kind of how the conversation goes.
No, that's great. And I think, dealing with indie developers and smaller developers, that's where these license agreements can come into play, where, be it a exclusive for a time-based, 2-3 years or whatnot, or even media, exclusive to games. Jeff, what would you say is the defining difference in these, kind of license deals versus work for hire where the composer gets to keep it? When do you know when is one of those appropriate?
I think it depends on your reputation, and I think it depends on your experience in the industry. Are they hiring someone just to create music for a game, or are they hiring you because they want you to make the music for the game? That's pretty much the bright line that I see. And again, if you're doing indie games and they're not really paying you your fee, what you're worth up front, then you have a lot more negotiating power to really give them a license to use it for the game, and you retain everything else.
That's how we use it. If we say, here's our fee, okay, you can't afford it, no problem. Here's our non-exclusive fee. And I'm always saying, it's the same custom music we're going to make for you for your game, but you can have it for cheaper, and we just kind of retain all the rights to reuse it if we want later on. So you do see some of that going on in the indie world as well, Sarah, with negotiations?
Well, I mean, there's really, if they can only pay like $1,000 a minute, for example, it's kind of a standard indie rate or maybe less. They can't afford to buy the rights.
For sure.
So, but there are things that they care about, which, it's important to understand what is it that they really need. And things that they often will care about are, I don't want this music heard anywhere else, or I don't want this music heard in another game. And so we'll say, okay, this is going to be a sync and master license, worldwide in perpetuity, so there's no time limit on it. You can have it forever and ever, because a lot of times when you're writing custom music for something so specific, how licensable is it? So, I mean, I have clients whose music is really specific for that thing, and even they say, no one is going to want this anywhere else. But the developer and the publisher really want that to be unique to them, and it should be. It's part of their IP. So what we'll do is say, it will be exclusive to your game, to your title, and maybe even anything related to the franchise, worldwide, forever and ever. However, there'll be a holdback period for anything non-interactive, anything non-video game, like a commercial or a TV show or a film or something. And we put a time period on it, 12 months, 24 months, 3 years, something like that, so that the composer has the opportunity later, maybe a chance, to exploit that and hopefully make up some of the lost income from taking the reduced fee.
We do that frequently, and then never end up relicensing it anywhere. But it is what it is. Yeah, and also sometimes with our clients, to convince them to do that, we will say, great, we'll do an exclusive license for X amount of time, and at the end of that, we'll give you the option to buy it out, for the exclusivity if your game is doing really well. And 99.9999% of the times it's not, and they're happy to have it lapse into some non-exclusivity, but it kind of makes them feel better that they'd have the option.
I think the important thing here out of this conversation is to take the time to think about your deals that you're doing and be discerning about what you're entering into. There is no such thing as a standard deal or a cookie cutter type of deal. Every deal is different. Every client wants something different. They have different needs, different concerns. think about those things. And as your career evolves, you get more leverage to ask for different things. So it's important for you to educate yourself about what rights do you have, and then start thinking about how am I going to dole out those rights. Do I limit them over time? Do I limit them for different media uses? What do I retain or what do I share? But it's about educating yourself as to what it is you're creating and what does your customer want and what are they willing to pay for.
And there's sort of an unfortunate irony sort of implicit in what we've been talking about here too, and that is the big deals, the straightforward work, I don't want to say cookie cutter, but straightforward work for hire where composer keeps soundtrack rights and it kind of hits all your bullet points. That's a relatively straightforward work for hire agreement. And it's kind of unfortunately ironic that with the indie games that have the much lower budgets, that's where you start getting creative. It's like, well, I'll reduce my rate, but if you treat me like an investor for the difference and then have profit on top of that, and how do you calculate? All of a sudden, you're now needing a much more sophisticated legal agreement, which is going to be way more money to hire somebody to write and vet and verify for what is a much lower dollar value thing. So that's it's just something to watch out for if you're working with indie companies, that what may sound awesome in an email or a conversation over coffee, to actually put that agreement to paper might be quite a bit more complicated.
It's important that you understand that when you're using an attorney or you're using other counselors and you're paying them by the hour, you have to use that resource judiciously. And
in 5-minute increments. I'm always afraid to call Jeff. I call and he's like, "Oh, how's your weekend?" I'm like, "Don't ask me how my weekend is, Jeff."
So have the conversation with your lawyer about, okay, and I'm always willing to work on a flat fee. How much is this worth? Okay, this is a $5,000 deal. I can't spend $5,000 in time. How much is it worth? Let's do what we can do.
For sure, yeah. Well, I have a bunch more questions, and an unlimited amount I could keep going, but I'd love to hit the pause button and kind of see if so far there's any audience questions. And just, Simon, to confirm, how long do we have till?
15 minutes.
Okay, perfect. All right, I saw a first hand right here.
Sarah, I actually have a question for you. First, thanks so much for kind of giving transparent answers to a lot of this stuff, because it's hard to learn about a lot of this sometimes. So you mentioned the idea of $1,000 per minute for a license deal, kind of as a standard thing, and I know there's no real standard. But if you weren't doing a license deal and it was a work for hire kind of thing, is there a standard per minute?
Depends on you, who you are, how deep your credit list is. It depends on where you're at in your career. There could be somebody, right out of school and they get offered $500 a minute. It's their first job ever, and I would say take that. Try to keep the rights, but you need to be working. You need to be making music. If that's going to be your career, you can't wait for the right thing to come along. You just got to jump on the train and go. But sometimes $1,000 a minute for an indie, $12.50, something like that, and then $2,000, $2,250, $2,500 for a mid-level. But some big companies will pay anywhere between that and much higher. So it depends. It's all about who the composer is and how is it worth it to the company to pay that much. And it also depends on their creative director on the game. How badly do they want to work with this person? If it's a big film composer, they're going to be paying thousands of dollars per minute. It just depends. There's no how much should I charge? It really should be, well, what have you charged in the past? And is this new project comparable to that? I mean, you just have to kind of weigh what you've done before. If you've never done anything, just make the deal and start writing music. You got to start building relationships to build a career. But if you've been doing this a little while and you have something to base it on, just you try to negotiate up a little bit. But it's really, money is just one of the buckets, right, that we fill. Is it good for my bank account? Is it good for my career? Is it good for my soul? And there might be a project that comes along that's so innovative and there's no game like it and you have to do it, then you make it work. So it just depends.
And Brian has some great data on this from his GameSoundCon annual survey.
Yeah, there's a survey. If you go to GameSoundCon website or search for GameSoundCon Audio Industry Survey, we break the industry down to 3 categories. It's hard to do that, but we do it anyway, or as best we can. Basically, AAA, the large budget Activisions, Microsofts, EAs, things like that. At the other end are indie games, which we consider non-professionally produced games, but that are more than just somebody in their garage that never really ships anything. And then there's a big swath of games in the middle, which are sometimes called casual core or mid-core games. And not that these are definitive or scientific surveys, but the average tends to be on the indie side. The range is $100 a minute to about $500 a minute, up to $1,000 maybe. This is for usually buyout. Mid-core is $1,000 to $1,500 a minute is the sweet spot, and AAA is that's where you get to $1,500, $2,500, $3,500 on up. I don't know about the mores.
A lot of great data in this survey.
It really depends a lot on the style of the size and scope of the company making the game, how professional they are. Is this a 20-person team that's funded through, has a $2 million Kickstarter, or is it a big publisher taking 5 years to build a major title? So it really is kind of all over the map.
Did you want to?
I was just, as a practical matter, doing this for 25 years or so, at some point you have to just sit down with a spreadsheet and figure out how long it's going to take you to do the work, and then figure out, okay, if I do it for X amount of money, that works out to $3 an hour, and can I live on $3 an hour, or do I need to bump it up from there? But if you're just lost as to, okay, where do I start, figure out how much time it's going to take you and what a good hourly rate would be. Do the math.
Yeah, and we talk about how much per minute is, and it's a convenient shorthand, but I know a lot of us really hate bidding by the minute. It's a terrible way to do it. I mean, think about Olivier's talk. How would you charge by the minute for anything that anybody has talked about so far today? It's impossible to do that. I'm sure Guy will talk about that later this afternoon. So what does that even mean to say you're a $1,000 a minute game composer? There's so much more you bring to the table, and I'll let Guy talk about that this afternoon.
Yeah, and we would love there to not be a per minute rate. I mean, there's not a per minute rate in film. You get a flat fee, a creative fee, or a package deal to score a film. There's a certain number of minutes that score is comprised of. In television, you get paid per episode, and it's either a 30-minute comedy or a dramedy, or a 45, 60-minute, 1 hour long drama, and you get paid per episode. But this is the only place where it's quantified that way. I would love to make flat, if it's under your estimated number of minutes, then fee doesn't change. If it's over, we'll give you more, and the fee doesn't change. But they say no to me a lot when I ask for that, so.
Awesome, great question, and was next on my list, so check. I saw another one right here. For sure, yeah, no, good question. Yeah, so the question about live performances like Video Games Live, Tommy Tallarico's orchestra, I'll let Sebastian go first in terms of money that can be had from this.
As a previous arranger and orchestrator, I think it's also important to mention that in most cases under US law, if you're creating, also I'm not an attorney, this isn't legal advice, in most cases arrangers have zero rights. Any kind of arrangement in sheet music or print form that is created, the copyright thereof befalls to the rights holder of the actual composition. So that becomes very interesting. But in terms of performances, if there are live performances of copyrighted compositions, it all depends whether it's a deal through a performance rights organization like ASCAP or BMI, where cue sheets would be submitted. I've also heard of cases where there are simple flat rates that are paid per song that is performed, for example. I mean, secondary market also includes, cover songs and CDs and sheet music booklets that might be sold. I think a lot of those, it just depends on the agreements that, people can come to a consensus for. In most cases, rights holders can be very excited about being approached about license deals because they don't have to do any additional work. Many game companies might not see themselves as music companies that license out rights. So there can be a certain amount of education that has to be done, lots of hand-holding. But I think concerts especially are a growing opportunity for video game music.
For sure, and Brian might have more insight. I would guess that ticket sales are the largest source of revenue in those concert series, but I don't know any.
And there's if you look on the MIGS site, the Montreal International Game Festival, 2000 last year, not this one that just happened. There was actually a panel where they specifically talked about video game music concerts. They had a European PR representative, and if my memory serves me correct, she said that a typical 3,000 ticket video game concert would generate about $10,000 in performance royalties for the one concert.
We should just get concerts going.
So,
Tommy's onto something.
I recommend you look that up because that's just by memory.
We can do 2 or 3 a day. We can
that's across the maybe dozen different tracks that are played.
Keep it going.
The follow-up question was, what if it's televised? If music is televised, then the broadcaster needs to pay. The broadcaster has an agreement with ASCAP or BMI or CSAC or whomever, and the network will pay ASCAP, and ASCAP will track that and pay the composers.
Yeah, I can kind of give a long answer to this, but to follow up on Sebastian, I am a lawyer, so I can't. This is not legal advice. This is just my opinion, and I also have a conflict of interest given the nature of your question. But music law is a really complicated thing, and it goes back to player pianos. When player pianos were invented, this was the first mass distribution technology for music. And there were 2 companies in the United States that created player pianos, and they both tried to corner the market by getting exclusive rights for the most popular songs. So if you wanted to hear a specific song, you had to have their piano. So in order to stop that, when the government gives you a copyright, they're giving you a monopoly. This was considered an abuse of that monopoly. So Congress stepped in and they wrote a law saying that if you're going to have music reproduced by player pianos, you got to let anybody who has a player piano do a copy of your music. And it's mandatory licensing, and I think this is mechanical licenses come from. So when the next technology came along, rather than making a universal law that it would apply to everything, Congress did the smart thing and they made a second law. And so now you have a royalty for player pianos, a royalty for a reel-to-reel tape, for phonograph records, for cassette decks, for CDs, for DVDs, for every new technology that comes along. If you buy a blank cassette, a blank 8-track, or a blank CD-ROM, there is a royalty that gets paid to the music industry and gets distributed through some bizarre, spreadsheets to somebody. But what you're talking about is mechanical license. So if you publish music in some form publicly, anybody can then do a cover of that music. And they have to pay the original creators a royalty. So 2 Live Crew did their take on Pretty Woman. The whole lawsuit was whether they had to pay Roy Orbison a royalty, and the court ruled, yeah, they do. So they have the right to create their song. It's a derivative work. They own their derivative work, but they have to pay the original rights holder something. So if you perform, if I want to perform, create a concert and do cover songs of another band, I am allowed to do that, but I have to pay that band royalties. So to answer your question, that's a long answer, but the bottom line is yes, they get paid. It goes to whoever the rights holders is. So if it was a work for hire, it would go to the publisher for the mechanicals and the public performance rights. And if it's also the case where the music was never registered with the PRO, which is the case for a lot of early video game music, then that music would just be played,
ASCAP would be paid for it, but ASCAP wouldn't have anybody to pay it out to.
Which is a whole nother panel.
Right.
When you register, you know, that track that you wrote on the PRO, and it's like, what's the name of the track, and what's the length of the track, and you put in that information, and you're like, great, now I'm going to get paid for it. Didn't upload it anywhere, isn't fingerprinted anywhere, no cue sheet submitted, but hey, they've got the name of it and the length of it. Gonna get,
I'm waiting for some band to just register Untitled Track 1 as a real composition and
it's
see what
like,
happens.
oh, great, yeah, we know how to pay you out for that. Anyway, another panel. Well, great, you know, I got my ISRC.
Do they take more than one? Yeah, that's not
Long
how
story
ISRCs
short,
works.
we didn't get money. Yeah, awesome. I think, are we out of time here, Simon? Thank you so much, Simon. Really appreciate it. And thank you so much, everyone. Really great stuff. Cool.